Namaskar. Welcome to the new episode of discussion number 1 regarding the new legislation Bharatiya Nyaya Sanhita 2023. Along with this enactment, the Parliament proposed to enact other two laws, that is Bharatiya Nagarik Suraksha Sanhita 2023 and Bharatiya Sakshiya 2023. Coming back to the existing legislation, it's a new legislation but replacing the existing laws. And what will be that, or what are supposed to be that existing laws? The first one is Indian Penal Code. Indian Penal Code has been enacted as early as in the year 1860. In the year 1834, the first law commission was constituted in India under the leadership of Lord Macaulay. The law commission studied the subject and found that there are different laws in different areas in India. So the commission proposed that let there be one law in the land in the form of Indian Penal Code, and the existing laws will be codified together. The other laws are Criminal Procedure Code. Earlier in 1898, the then Criminal Procedure Code was enacted, and that has been subsequently replaced by Criminal Procedure Code 1973. There is yet another law, that is the Indian Evidence Act 1872, that also be enacted in the erstwhile British India. It is commonly said, justice is the goal to be achieved and the law is the means. And this is a difference between justice and law. Normally, the common people misunderstand justice and law. Though both are part and parcel of same system, there is slight difference. According to jurisprudence, justice is the goal to be achieved and the law is the means to achieve that goal. What is meant by justice after all? It's nothing but give everyone what is due to him. It is commonly said, give the devil his due. So even the devil is entitled for his due. There is no person like devil, but for expression, the jurists say, give the devil his due, means everyone should get what is due to him. And in legal parlance, the due are divided into two. One is legal rights and the other one is legal liabilities. And the legal maxim says, you be just, you be remedium. If you have a legal right, then there is a remedy available for you. So the legal right is what the one that is provided under law as part of justice, and to arrive at that right, that goal, that what is due, there is a procedure established by law, and the legal system is there in the form of substantive law and procedure established by law. And the law is the means to achieve that goal. As I have already told you, law is again divided into two, substantive law and procedural law. Substantive law defines what is your right and what is your liability, concerned with everyone. And there's a procedure established by law to achieve that substantive right, that is a procedural law. So every law is divided into two, substantive law and procedural law. Coming back to the existing law, Indian Penal Code is a penal provision. In the penal law, the punishment and the crime are there. law defines an act to be a crime. And if that crime is committed, what is the punishment for that? That should be arrived at in a trial. That is simply what the penal law is. Unless an act defined to be an offense, no one can be punished at law. That is the guarantee provided under the Constitution of India. Article 20 of the Constitution, ex post facto law. So, first of all, an act to be defined as an offense by a particular statute. And the Indian Penal Code is the main legal provision or enactment in which the acts are defined are offenses. For example, murder. Everyone knows murder. What is murder? Murder is an offense. So, how the offense of murder is constituted? That is defined under section 300 of Indian Penal Code. In order to constitute the offense of murder, there are certain ingredients. The first ingredients will be killing of a human being by another human being. Suppose a person dies by the attack of an animal, that will not be an offense of murder. So, killing of a human being by another human being is the first ingredient. The second ingredient will be that killing must be done with an intention to kill. Suppose if the doctor, while conducting a surgery, and as a result of the surgery, a patient dies, does it amount to murder? Does it amount to an offense? Can the doctor be punished? No. Because the doctor acting in good faith to save the patient, and he is conducting surgery, and the patient is informed that due to a surgery, it may result in your death also. Are you ready to take that risk? That is why before every operation or surgery, the consent of the patient or close relative of the patient is obtained by the hospital authorities and the doctors. That they are ready to take the risk. It is known in the law as voluntary non-fit injuria. The patient or the close relatives voluntarily accept the risk. And finally, surgery is conducted. So that is also not an offense. So killing of a human being by another human with an intention to kill, then only it becomes an offense of murder. Of course, there are other certain ingredients that we will study later. So likewise, in the Indian Penal Code, different offenses are prescribed or enacted or made as an offense. There are as many as 511 sections in the Indian Penal Code. And these sections are again subdivided into chapters. There are as many as 23 chapters in the Indian Penal Code. So this is the existing law that has been enacted as early as in the year 1860. The existing Indian Penal Code also consists of the punishments. If an offense is committed, what are the punishments? So if an offense of murder is committed, the offense is either death or imprisonment for life, and fine also can be imposed. So this is the existing punishment. Likewise, in all other sections, offenses are defined, offenses are made punishable, and what are the punishments that are also stated in the Indian Penal Code. Now the new enactment, BHARATIYA NYAYA SANHITA, is a new legislation. The existing law can be amended and certain sections can be deleted or added. That is amendment. But if a law completely removed and a new statute be brought in, that is known as repeal and enactment of new law. Now the Indian Penal Code is going to be repealed completely and a new law is to be enacted or going to be enacted by the Parliament by name BHARATIYA NYAYA SANHITA 2023. In BHARATIYA NYAYA SANHITA, there are as many as 356 sections. In the Indian Penal Code, there are as many as 511 sections, And in the new Bharatiya Nyaya Sanhita, it is 356 sections having in the code. This again divided into 19 chapters. In the earlier code of Indian Penal Code, there were as many as 23 chapters. In the new Bharatiya Nyaya Sanhita, there are only 19 chapters. So actually, the number of sections are reduced in the new legislation, Bharatiya Nyaya Sanhita. Coming back to the other laws. In Indian Penal Code or Bharatiya Nyaya Sanhita, offences are defined, punishment are prescribed. What are the procedure to arrive at whether a person has actually committed the offence or not? That is to be done under the procedure established by law. In every case, there will be a trial. It is just like diagnosis of a patient by a doctor, whether this patient has got an ailment or not. So, diagnosis process in simple terms, that is trial. In the trial, both parties, both prosecution and the accused, are given opportunity to adduce evidence. And there will be arguments, consideration of law, and finally the court will pass a judgment of conviction or acquittal whether the accused is guilty or not. The person against whom the criminal prosecution is initiated, that person is known as accused. And after the trial, suppose if the court convict that person that he committed so and so offense, then his nomenclature will just change from accused to convict. And suppose in a diagnosis, the doctor finds that the patient suffers so and so ailment, the doctor will prescribe the medicine or treatment. Likewise, once a person is convicted, then court will impose adequate punishment as per law. And then that person be sent to prison or the punishment he has to undergo. And finally, after undergoing punishment, that person can be set free. It's just like treatment in the hospital, and after the treatment, the patient gets cure of the ailment, and finally he comes out as a normal, healthy human being. Likewise, after the jail or imprisonment or after suffering the sentence, that person or the accused or the convict finally comes out as a normal human being to the limelight of the society. That term is legally known as reformative theory of punishment. There are other theories of punishment that we will study later. So this is a procedure. Now, this Criminal Procedure Code 1973 is going to be replaced by a new enactment, Bharatiya Nagarik Suraksha Sanhita 2023. So the present Criminal Procedure Code is going to be replaced by a new enactment. The present Criminal Procedure Code consists of 484 sections that be divided into 37 chapters. It also includes 2 schedules and 56 forms. Now the new enactment, Bharatiya Nagarik Suraksha Sanhita, consists of 533 sections. Sections are added new. And one more chapter is added. So now the Bharatiya Nagarik Suraksha Sanhita has got 38 chapters. 2 schedules and 56 forms are there in the present Criminal Procedure Code and new Procedure Code. So that are retained, of course, with certain amendments or changes. So that is the new legislation, Bharatiya Nyaya Nagarik Suraksha Sanhita 2023. The Indian Evidence Act 1872, that has been continuing for years together, decades together, centuries together. This act is going to be repealed and a new enactment will be brought in, and that is the name is Bharatiya Sakshya 2023. The existing Indian Evidence Act, consisting of 167 sections divided into 11 chapters. The new Bharatiya Sakshiya 2023 will be having 170 sections. Again, it will be divided into 11 chapters, and 2 schedules are also added with the new Evidence Act or Bharatiya Sakshiya. So that are the major changes brought in the structure of the Act. Now the question is, what is the need of the hour? Why the law is to be changed? Is it necessary that the laws are to be amended or new enactments be brought in, or the existing laws are to be repealed or not? So that may be a question among common public. One of the jurists, John Austin, said, "A law is written in the hearts of men by the hands of God." Means everyone has got a conscience, our heart, in which we know what is right, what is wrong. But as far as the penal enactment are concerned, we cannot live according to whims and fancies. What is right to a person may be wrong to another one. So there should be something common. So the laws are to be codified so that everyone will be following the same law. Otherwise, we cannot achieve the goal equality before law and equal protection of law. So this is the major difference between enactment and code also. In a code, the existing laws are arranged systematically, and it has been given a systematic form of law in writing. So existing law may not be in a written form, it may not be the same, it may be scattered. But when it is codified, then it will be in writing, and it will be numbered consecutively in a systematic manner. But act or enactment, new law, is something new that is legislated by the legislature. For example, Protection of Children from Sexual Offences Act 2012. It's a new enactment. This is not a code. It's a new law brought in. So new laws are brought by the parliament or the state legislature concerned in the form of act, which will be a law according to the procedure established by law, including getting the assent by the president or the governor, as the case may be. But if a new law is brought in, it is known as act. If the existing law is rearranged or codified or be brought in a written form in a systematic manner, that is known as code. The new laws, Indian Penal Code, Criminal Procedure Code, and of course Indian Evidence Act is known as Act itself, and the new enactments, actually it be a codification and a rearrangement. The first and foremost reason for enactment of new law is to make it contemporary. Indian Penal Code has been enacted about a century back. In the year 1860, the first law commission was constituted as early as in the 1834. It continued for years together, of course with some changes. So the parliament thought it is appropriate to amend the law and make it contemporary. Contemporary situations are considered. And one of the arguments made is that when Indian Penal Code was enacted, we were undergoing colonial system. Now India got independence, so why can't we make it domestic? Why should we follow the colonial system of law? So some changes can be made, make it contemporary. And for example, at the time when Indian Penal Code was enacted, the mobile phones, computers, and the other digital devices were not there. So laws are to be amended to that extent that new changes of the hour or the time can be brought in. That is what is making contemporary. So Indian Evidence Act is also amended in the form of new law of Bharatiya Sakshiya, and its digital evidence the electronic evidence